Here.
Hey everyone, we are going to get started. Welcome to everyone in person as well as online. Good afternoon and welcome to the O'Donnell Consent Decree public meeting. My name is Dr. Natasha Willis and I am the Program Compliance Manager with the Justice Innovation Team at the Office of County Administration. For those of you who may be attending a public meeting for the first time, following a class action lawsuit against Harris County claiming the misdemeanor bail system was unconstitutional, a settlement agreement was reached known as the O'Donnell Consent Decree. The consent decree represents the first federal court-supervised remedy governing bail. The mandate requires oversight and accountability of Harris County and all parties involved. All parties recognize that the input and involvement of Harris County residents are essential to meaningful and lasting reform, which will be effective for ongoing system monitoring. As a result, we hold these public consent decree meetings. To read the consent decree, annual reports, or other related O'Donnell information, please visit oca.harriscountystx.gov. We are currently in year 6 of the 7-year consent decree, with this being the first public meeting of the year. Here today to provide an update on the consent decree implementation and an overview of the 8th O'Donnell Monitor Report are Independent Court Monitor Professor Brandon Garrett and Deputy Monitor Sandra Gira Thompson. With them is the Honorable Judge Erica Ramirez, representing the County Criminal Courts and Law, Attorney Seth Hopkins with the Harris County County Attorney's Office, and Major Matthew Ferguson with the Harris County Sheriff's Office. After the updates from the monitors and parties, we will open the floor for public comments and questions. With that, I turn it over to Professor Garrett.
Hello, welcome everyone. It's again a privilege for Sandy and I and our colleagues to serve Harris County in this role, and we're really grateful for the collaboration of Judge Ramirez and her colleagues on the court, and Seth and his colleagues in the County Attorney's Office, and Major Ferguson and his colleagues in the Sheriff's Office. Also grateful for the collaboration of others who are not formally parties to this case, but who've been invaluable. We were just meeting with the District Attorney's Office. This is, we've been doing this for 5 years now, and in some ways our reports haven't changed since our first report, way back in 6 months into our work in the year 2020. Some things have not changed. We've continued to see a decline in the number of misdemeanor cases, roughly a 15% decline in the number of misdemeanor cases in Harris County. And some because of some programmatic decisions to deprioritize some types of the lowest level misdemeanors. But we also know that repeat offense numbers have gone down as well. So the whole system has shrunk somewhat. It's still a very large system. It's still 42,000 cases a year. That poses, great burdens on our courts and our public officials to manage these cases properly, consistent with public safety. But overall, we've seen public safety benefit. And going into this role, we weren't sure what would happen. It was new to make changes on this scale in a jurisdiction as big and as important as Harris County. There are a few new things in this report and findings that I just wanted to quickly highlight for everyone. Just like when we met the last time, when we're rushing because I think Beyonce was in town, and so everyone was expecting a lot of traffic. And I know Judge Ramirez and her colleagues will appreciate me mentioning this first. There was a great deal of backup of cases after the pandemic, and that affected courts around the country, and it affected courts here in Harris County. But we can report today, just like we did when we were last here 6 months ago, that every time we come back to see you all, every time we report to Judge Rosenthal in this case, we're seeing the time that it takes to resolve misdemeanor cases go down. More cases getting resolved earlier, and it's just, we see that every 6 months, the enormous progress that the criminal county courts of law have made. And what was a real burden, that big group of cases where you didn't have trials easily happening during the pandemic years. And so it's, we've tried to put those years behind us in all of our work. And it's been remarkable to see the courts do that, because that was an incredible challenge and a big lift that also obviously for the appointed counsel, public defenders, NDAs. Again, we've continued to see that the numbers of misdemeanor arrests and rearrests have declined. The rate at which people are rearrested has stayed the same really for years and years and years going back. Most people do not receive a secured bond in misdemeanor cases, and most people are not jailed in misdemeanor cases in Harris County anymore. That was not true before these rules came online under this consent decree and based on the preliminary orders before there was a consent decree. And so it's remarkable that although many, many fewer people are jailed in misdemeanor cases, public safety has benefited from these changes. A few new findings which are interesting, and we really wanted to highlight them. Seth Hopkins may speak to this, but a whole range of county collaborators, including the clerk's office, the Office of Courts Management, and others have done important work, Universal Services, to set up moral supports of different types for people to appear in court. And it certainly doesn't benefit a lawyer's client if the client doesn't appear in court, and it burdens judges, dockets, and other professionals, and it can have negative consequences for the person if they don't appear in court. There were some rockiness, which we described in our reports more than a year ago, in the implementation of the electronic notification system, but those, with a lot of help, the issues with getting those electronic notifications to the person that was supposed to receive them have been almost entirely sorted out. And we can now look at what happens when large numbers of people are getting this new type of reminder to come to court that they weren't getting before. And as we describe here, and thanks to the team at Texas A&M for carefully examining this data over some time, they found that court date reminders reduced the odds of missing arraignment by 50%, which is really quite remarkable. A second type of support that we were evaluating is for people. We found that the odds of missing arraignment are 31% lower for people who are engaged by this program. And also really, really remarkable and interesting finding. Those were the main new things that I wanted to highlight. I'm sure people have questions, and we're happy to talk about anything else that we've reported on. These reports of ours are long, but most of our findings have been very consistent for years now and have been really positive. So we're happy to be able to report that, but also that some of these new supports that have been rolled out have had a real impact. So that's all I have, at least to begin with. Do you want to add anything more?
Okay, sure. Hi, I'm Sandra Guerra Thompson. I'm a professor at the University of Houston Law Center, and I serve as the deputy monitor for O'Donnell. And part of the role, since I'm here in Houston, unlike the rest of our team, which is in other cities, other states, is, I try to keep the pulse of the community a little better. And I just want to echo some of what Brandon has already said, that what we're finding here is that the changes that were made as a result of the litigation in O'Donnell have been really positive for the community. And we've had some really exciting meetings and shown a film that was produced by a group in town about freedom stories of people who have had some kind of brush up with the law, ended up getting arrested, and because of O'Donnell, they were able to be released pretty expeditiously without having to pay money, which they wouldn't have had, and not have their lives fall apart, because folks have people in the community, family members that are dependent on them, who they can't just suddenly be gone without their lives really falling apart in a horrible way. And so O'Donnell has been very, very positive for the community. It's a success story. And if you listen to a lot of the political campaign ads, that's not what you hear. Or even, some of the stuff that's being said now with the legislative session that's currently going. So if, I just want to urge the community, if you're hearing things about how dangerous bail is, what Brandon just said was that we were able to decrease the racial disparities in terms of who was released from jail without having to pay money, or who was released at all. And that has not impacted, right? So lots and lots of people have been able to get back to their lives after a minor arrest, and they're showing up to court, and they're facing whatever punishment they may deserve or not. And at the end of the day, this hasn't affected public safety. And so we're very grateful for all the community support and all the support of stakeholders. Brandon rattled off a lot of different groups. We've also worked with the Public Defender's Office, with many agencies, nonprofits, and organizations. There's so many incredible advocates around. We had meetings last night that were very exciting in Precinct 4. Want to send a shout out and thank you to County Commissioner Leslie Briones for hosting us. And our county commissioners are also supportive in this way. So we're very grateful for all the community support, because really this, at the end of the day, this is a civil rights issue and a success story. Or as one of our community members last night said, a human rights story. It really is about human rights. And there's still a lot of work to be done. We're seeing a lot more ICE holds, for example. And that's kind of tragic for people to be held on really trivial offenses only because they have an ICE immigration hold. But in any case, yeah, so we're very grateful, and we just want to emphasize that this has been a real win for the public.
Okay, so we'll start with Attorney Seth Hopkins. Any comments?
Hi, Seth Hopkins with the Harris County Attorney's Office. And first of all, I'd like to thank the monitor and the monitor's team and all of the folks in Harris County who have worked to comply with the requirements of the O'Donnell consent decree. And I believe the monitor mentioned a couple of the key players. The Office of Court Administration is represented, the district clerk, some of the programs such as the CARP program, pretrial services. There are a lot of elected officials and unsung heroes who show up every day for work and have worked very hard on complying with these obligations. There are no legal updates with regard to the case. Our office has been involved particularly with the Section 55 plan, and Section 55 of the O'Donnell consent decree works to try and get appearance rates up so that when people go through the Joint Processing Center, they come out of jail, they're initially arrested, that they go to their hearings so that the process can continue and can move speedily along. And we recognize that a key part of that is education, making people understand what these appearances are about and making sure that they understand when and where they're going to be. One of the first key things that we did is we created a website that we talked about at our last public meeting, myharriscountycase.com. There are now posters in the jail in 5 different languages. From the moment that you are first arrested, you'll see them throughout the process. As you're getting your property back, your phone back, there's at the out processing, there's a phone charging station. There are posters in 5 languages, and there's a QR code that you can use your phone, you can scan, and you can know when your hearings are going to be. The next phase that we're working very closely with the judges on and pretrial services is to create educational videos so that while you're going through the process, you'll have videos that'll explain what your rights are, what the process is like. You'll actually see those, we hope, soon in the Joint Processing Center, so that when you come out of that initial arrest process, you'll be more informed about what your rights are. So that's one of the next phases, and we appreciate the pretrial services and the judges and the work that they've done with that. And we're here to help them out in any way that they need to create those videos. And that's our update.
Judge Ramirez, and you might need to put the mic down a little.
Happy Friday, everyone. My name is Erica Ramirez. I serve as judge of Harris County Criminal Court at Law Number 8. It's one of the 16 misdemeanor courts, and I'm also serving as presiding judge here in Harris County for the county criminal courts. I want to thank y'all for being here today. It really matters. The work is important. We appreciate your interest in it. I'd also like to thank the monitors for their continued work in documenting our compliance and progress. Our justice partners who've been working closely with us in the efforts to ensure that we have a constitutional bail system. The Harris County Criminal Courts at Law continue to be committed to ensuring safe and effective bail reform. Misdemeanor bail reform is designed to level the socioeconomic playing field. It ensures that no one remains in jail simply because they can't afford it. Bail is not meant to be a tool of oppression, but a way to maintain public safety and ensure folks who are presumed innocent and charged under the law return to their court date. Rather than focusing on their ability to pay, bail reform allows us to focus on two key issues that are really important. The first one, is this person considered a danger to the victim or to our community? Second, what is the likelihood that the person will return to their future court dates? Appropriate bond conditions such as protective orders, pretrial supervision are used to mitigate potential risks. The ultimate goal, again, being able to ensure community safety, complainant safety with effective conditions, but not excessive conditions. You know, we're proud to note that we're continuing to make great strides in reducing misdemeanor case backlog. I don't know if it's really well known. National standards call for misdemeanor cases to be disposed of within 180 days. Cases are considered backlogged when they're active after that 180 days. Our backlog, as we know, we hear it over and over, is consistently with Harvey, COVID-19, but we've also got delays in receiving evidence from law enforcement. Since January of 2022, we have cut our backlog, I'm very proud to say, by 72%. We've gone from 24,457 to 6,899 backlog cases in our misdemeanor courts. That's phenomenal. During the same time frame, we have cleared over 184,000 cases overall, and that's an average of 11,500 cases per court. Additionally, our average clearance rates are well over 100% and as high as 124% this past February. So for context, last April we reported that we had a 65% reduction of the backlog. Now we're at 72%, and it indicates steady progress. So the success is a result of our continued focus on best practices, increased efficiency, good leadership, and data-driven decision-making. We're committed to continuing the work because it helps ensure that justice is timely accessible to all that come before us. We are requesting 4 new county criminal courts at law to better tackle the increasing criminal misdemeanor caseload and to better serve our community's growing population. National standards call for a jurisdiction as big as ours, Harris County, to have 27 and a half courts. We only have 16. We have worked hard, very hard, to cut back our backlog by nearly 3/4, which goes a long way towards ensuring dockets are more efficient, but that breakneck pace cannot be sustainable. It's not sustainable for the long term, especially as our population, our community grows. The addition of 4 courts would significantly improve access to justice and move cases more rapidly through the system. We're in the process of getting formal approval from the County Commissioner's Court, and if they approve, then we are going to move on and ask the Texas legislator. We sincerely hope that they support us with the addition of 4 county criminal courts at law. Our community deserves an efficient and accessible court system that resolves cases in a timely manner. That concludes our update. I'm very happy to be here, very honored to be a member of this community and to see the progress that we've made.
Thank you. And we welcome Major Ferguson.
Good afternoon. Thanks to everyone taking time out your day to come up here. And also thanks to the panel up here for giving me the opportunity to join you. Some of the words that were spoken up here are very poignant, especially the videos to instruct individuals on their rights. That's very good stuff that we could use, that we could easily put up to help out. That helps us. So we don't have to sit there and explain with limited information, limited knowledge, what your process is. So that's very, very good. Best practices in additional courts. We want to see the inmate population go down as well. It helps us, it benefits us, and we want to get them through and to their attorneys and to their court as quickly as possible. So whatever we can do, as a representative of the Sheriff's Department, let me know. I'd be glad to help you. Thank you.
Thank you so much. Okay. We will now begin the question and answer portion of this meeting. We'll start with in-person questions and then take questions from our online audience. For those in person, if you have a question, please come to the podium, state your name and affiliation in the microphone before asking your question. For those online, please list your question, name, and affiliation in the chat for me to read aloud after we take in-person questions. So we'll open it up to the public. Any questions?
Hello, y'all. Good afternoon. My name is Selena Bray, and I'm with the Pure Justice Organization. I do have a question. So at the criminal jurisprudence hearing with the Texas committee passed this week, there were a number of individuals who mentioned that the O'Donnell consent decree has contributed to misdemeanor bail issues and that it's ultimately deadly. I think that the fear is that individuals who are not detained pre-trial are committing slews of crimes, being released on personal bonds, just a lot of negative public safety impacts. As y'all have communicated, the data does not confirm that. Wondering if y'all have specific communication strategies on making it very clear to people that that is not the reality, especially given the politicized nature of bail reform.
Sure. Yeah, I didn't watch those hearings. I'm one of the out-of-state members of our monitor team. But certainly in our reporting to the judge in this case, and that's our main, in our role, our communication, we don't have communication strategy, right? Our role is to report to the federal judge and to the Harris County public, our findings, and we're law professors, we work with academics. We are, supposed to be politically savvy, and we're not. I mean, we say in this report, like in our past reports, I guess the main data point that's relevant to concerns about not just misdemeanor reoffending in general, which we've described how the numbers of people reoffending has gone down and the rate has stayed the same for years and years and years. But the most serious type of reoffense would be, felony repeat arrests, although not all felonies are the most serious either. But just taking that, the rate of felony repeat arrest has been between 11 and 12% going back years and years and years. But that's also 11 and 12% of a smaller number of people. So there used to be more like 50,000 people a year arrested for misdemeanors. And, 11 or 12% of those would go on to commit a felony. Now it's more like 40,000 people a year. And it's about 11 or 12% that go on to commit a felony. And so that's for the more serious type of repeat arrest, the news has been very, very positive. And so I don't know on what sort of evidentiary basis someone would say that crime is going through the roof. What we have found is that repeat arrest, even the more serious felony repeat arrests, have declined in numbers and remained exactly the same in terms of rates. But I leave it to those of you in the community to do the communicating. Our role is to report to the judge, and although our reports are kind of long and technical, we did try to flag up front the importance of those public safety oriented findings. And so we have tried to at least highlight them up front and highlight them when, reporters want to talk to us. But, we don't have communications staff. We're just monitors reporting to a judge. But we do hope that in your communications, and if you, have people testifying or talking to the press, that you highlight that these policy changes have been positive for public safety. And I understand why it's hard for people to appreciate that. I just think it's understandable common sense that people would just think that, well, putting people in jail means that they can't commit offenses, and that must be good for public safety. You can't have liberty and public safety at the same time. It's like a trade-off. It's like zero sum. And that's not how it works. And in fact, under the old cash bond schedule that was in place, there wasn't a lot of detention of people that benefited public safety. Many more people were jailed, but typically for just a few days. And they would often plead guilty and then get out. It actually, there's some evidence that it actually contributed to crime to jail those people for several days rather than promptly release them for these very low level offenses. On the flip side, for those who care most about public safety, and people should care about safety quite a bit in their communities, obviously. What we haven't described as much today is that these O'Donnell changes also provide more resources than existed in the past for the cases that raise the most public safety concerns. And so when you're mass processing everyone at bail hearings in misdemeanor cases, the bail hearings were often 30 seconds long, 60 seconds long, and there wasn't a lot to talk about at those hearings because there was a rigid schedule. Oh, so you're driving with a suspended license? That's $2,000. That's all there was to talk about. People didn't have public defenders, and even if they did, there was nothing to say. The magistrate was required to follow, like sort of robotically, a schedule. It was a mechanized system. Now, in the more serious cases, which we call carve-outs under the Rule 9 that the judges adopted before the consent decree formally took effect, the more serious cases, people who are in violation of probation or bond, domestic violence cases, repeat drunken driving cases, DUIs, there's several categories of more serious misdemeanors. Those go to a bail hearing, and those bail hearings are not 30 seconds long anymore. It's not prolonged, it's not a trial, it's not supposed to be a trial, but there's a real hearing with presentations by the district attorney and the public defender and an actual conversation and back and forth. And often it's not long, but it'll last, 5 to 10 minutes. It's a far more robust hearing to discuss the merits. And is there a public safety concern here? Are we worried about the safety of this person in the community? And what are the appropriate conditions if the person is released? And then it goes before a judge, Judge Ramirez or one of her colleagues, to then revisit those conditions over time and decide what's right. And that's very different. The idea that the old system was better for public safety, like public safety wasn't even part of the conversation when all that was followed was a bail schedule. So, but again, our role isn't really to be, we're not advocates. Our independent reporting to the court is our role. But many of you have different roles in the community, and we hope that you share our work.
I would just add that, like the simple message is that O'Donnell only approves of release for people who have not been accused of a violent or serious crime of some sort. So the carve-outs that he's talking about are the cases that present more public safety worries. Those aren't part of this.
Right.
So it's really only affecting, and there are huge numbers of people who are arrested for nonviolent, relatively minor offenses. And those are not the people we ever really wanted to keep in jail. So why make anybody have to pay money? If we just remind people, that's really all that this is about. Because a lot of times the political ads and such, they're really focusing on people charged with felonies.
Yeah.
And that's not what this is about. So thank you.
I wanted to add to that. What a great question. I'm glad that you watched it. I watched it too. As judges, we have strict canons, so I can't go on my Facebook and rant like I wish I could. But the reality is that we do go out to the community, go to super neighborhood events, go to any community event to educate folks. We do that, and we depend on amazing community members like yourself to also educate folks. And just like Professor said, these are misdemeanor Class A and Class B, punishable up to 1 year and 6 months. We're not talking about the violent offenses. We're talking about, again, we talked about DWIs and assault family members, but we're talking about mostly thefts, a criminal mischief, which is damage to properties, failure to stop and give information. So we're not talking about really the the big, scary community safety cases. And I think I have one memory as a prosecutor many, many, many moons ago. I remembered that it wasn't uncommon for folks to be in jail for a driving while license suspended case, and in jail because they couldn't afford the bond. Now, it's just incredible to see the change from many moons ago to how it is now. And I'm grateful for that.
Thank
Thank you.
you.
Any other questions from the in-person audience? We do not currently have any questions online. So is there anything else from our panel? I'll give online folks another minute or so, but anything else from our panel? Yes, okay.
Hello. Hi, Larissa Bretta from Precinct 4. Thank you so much for all the work that everybody does here. Wondering if you could speak a little more about the findings that you had with CARP.
Sure. So I guess there are two aspects of those findings, and Toddy Carmichael and David Sheep from Texas A&M are in the audience, and they could say a lot more. And they've been the ones taking the lead on studying that data really carefully. So it's the Community Assistance Referral Program. It has engaged quite a few of the people who are released on the general order bond. So obtaining a fairly prompt release from the JPC. They've engaged over a third of misdemeanor defendants. They also provide service referrals to those people, and it may depend, the number and type of referrals may depend on what needs are identified. So in general, that I described this about a third reduction in missed arraignments for the people engaged by this program. But there's a second finding, which is also really interesting, that the people who are really, really high needs, who receive more referrals, including for just very basic things like they need help with having adequate clothing to wear to a court date. The people who have the most referrals the highest needs people aren't helped as much by this and clearly need just a lot more help and more supports. But that also suggests, like, these are some of the people who are facing extreme poverty, who have behavioral health needs. It's not about willful non-appearance, but it's about severe challenges that such people have. And it may be that additional resources for such people could both help them get on their feet and make it more possible to proceed with their cases. So that's, there's a separate important question whether additional work could be done to kind of locate those individuals and think about what kind of diversion and resources, because it may be that proceeding with the case, something in court may not be really what is needed to both get that person on their feet and make sure that they aren't doing things that implicate public safety. And so CARP resources, those kind of referral resources, may help the courts and help the prosecutors and defense lawyers proceed with the case, but it may be that other resources are needed so that that person doesn't cycle through the jail and the courts as well.
Okay, some online questions are starting to roll in. We have a question from Joy Davis that states, it was mentioned that the racial disparities based on who were given bonds were reduced. Was that broken down by court numbers as well?
No, and in general, it was, well, and actually, so, those disparities that we had seen in terms of who was able to make bonds, who was able to pay cash bonds or not, those reflected decisions by hearing officers at the time, and so not typically the judges, although before these policy changes, the misdemeanor hearing officers were following a bail schedule that was designed by the court, but it wasn't by any particular judge, right? It was a court-wide policy to have a cash bail schedule. In many parts of the country where I live in North Carolina, there's still a cash bail schedule that is roughly followed. It was strictly followed in Harris County. And so there weren't really supposed to be differences between hearing officers or courts. It was a unified policy, which was ultimately found unconstitutional. And so, and what we found was that that policy had very uneven effects on people based on race, and that those disappeared in terms of a racial disparity in who was getting secured bond and who wasn't. That disappeared once these reforms took effect, both first with the preliminary injunctions and then with the Rule 9 that the judges adopted, which was then incorporated into the consent decree.
Thank you. Okay, we have a question from Saif, the Harris County MAC office. The question is, have the monitors had the ability to watch bail hearings in county criminal courts? And are you satisfied with the level of advocacy by defense attorneys? And then I'll read the next part.
Okay. Yes, we do. So the courts share videos with us, and also with counsel for the parties. And so we do watch. I mean, we don't watch all of them. There are many hours of videos, but we do watch some of them. Sometimes if there's a particular hearing that counsel mentions that something went well or went badly, but mostly we just watch videos randomly. We try to watch videos across the different hearing officers, different times of day, just to get a sense of how they're going and to be able to give feedback. We had pretty regular meetings with the magistrates early on in our work, and it's been less frequent since then. We talk about this a little bit in our report. I mean, we're just always impressed with the patience, the demeanor of the hearing officers. They have long and crowded dockets, often at times of day when many of us would prefer to be sleeping. And in terms of the advocacy of counsel, well, I don't know. So in terms of the advocacy at those hearings, they're not lengthy hearings. I guess the one topic that we noted doesn't come up as often as we think it might is there's often not discussion between the parties or with the hearing officer around what the appropriate conditions are. It's often mostly focused on should this be a secured or personal bond, but not on what are the appropriate conditions for supervision in the community. And we do think it would be productive to often talk about, well, what are the right conditions? And in terms of if what the question was, well, do we also observe what happens in the courtrooms? Some of the courts are live streamed, and so we have watched those from time to time. We also, when we went to some courts in person, maybe our public meeting before last, we spent some time visiting some of the misdemeanor courts, but one can also, the members of the public can watch them online. Now, of course, there are all sorts of hearings that one watches. There can be trials going on, which is really interesting to watch. And, people in the public should come to court and see what it's like. And, can just, totally law students, like, it's good to watch trials. So, we in general, like, it's hard to identify in advance. Okay, at 11 a.m. there might be some bail reviews, and we can listen to what the judge is saying as they're hearing from the sides concerning bail reviews. So it's a little hit or miss if you're watching those to locate the bail-oriented hearings, since other things can be going on. There could just be scheduling hearings or discussions of discovery or trials. But from time to time, we have watched those. And I don't think I have any particular comments about advocacy. I guess the main comment that I have that we talked about a little bit in the report was that there had been an effort supported by some outside researchers at the Harvard Kennedy School to more proactively identify cases that had conditions that the person had complied with, and so you could step down those conditions, and they were testing whether whether that kind of stepping down of conditions, if the person was complying, was okay for public safety purposes. And several judges participated in this pilot. The results were really powerful. They found that proactively revisiting conditions regularly benefited public safety. The outcomes in those cases were good, and their cost savings to reduce sometimes some types of supervision could be quite expensive. But they had a grant to do that pilot program, and that kind of proactive revisiting of conditions doesn't normally happen unless council does bring it up. But our sense is that it isn't often a routine thing that council will bring up. So it would be wonderful to explore some version of that again, so that there's at least a conversation about conditions that's programmatic. We did know also in
I
our
was
in our
pretty
report
excited this morning too, that the district attorney's office is also very much in support of that, moving forward with that. So, it's nice, like if the MAC, I'm sure the MAC and the public defender's office would support, obviously they would support something like that. But, so we've got really all of the litigants agreeing that, if you have this person on a misdemeanor who's out on bond and they have to fulfill all these conditions and they're expensive, and we find that they really don't need them anymore. That we could step down from that gradually. So it would be nice to see a more systematic way for that to happen, because council are not raising that on their own very often, from what we hear from the judges.
And the last part of the question says, and do you believe the courts are adequately engaging with the Rule 9 requirements, such as clear and convincing evidence standard?
I think that comes up that's the standard that applies when you're reviewing bail conditions.
Mhm.
And we do see the written rulings and also the oral rulings that hearing officers make. And they do, discuss that standard and discuss what facts satisfy it. We've certainly identified situations where it is hard to tell from the ruling, like why was the evidence enough or why was the evidence not enough. In general, though, and we say in this report too, we've been really impressed with the detail of the opinions and how they've really changed since the early days of the consent decree, when it was an unfamiliar standard. We see a lot of engagement with the constitutional standard, that there has to be some fairly substantial evidence that you're concerned about this person. And it's reflected in the words they choose, but it's also reflected in what we see in terms of the care with which they pick the cases where they think that they describe why there is a real public safety concern and why the person should be held, or why a more serious secured bond should be imposed.
And I guess he had for clarification, wanted to state that he was referring to the bail hearings in the county courts that happen the day after magistration. So I'm not sure if your answer would particularly change.
Well, so that's a little different. So there's a right to, it's kind of like an appeal. So after the hearing officer reviews one's, what bail is appropriate, a person has the right to have that bail determination reconsidered by the judge. So it's called a bail review. It happens the next business day. So it might not be the next day if there's a weekend in between. One challenge at that hearing, so a public defender has met with the person and prepares and represents a person at the bail hearing in front of the magistrate, but a person may not have had counsel, will not have had counsel appointed for them when they have the bail review the next day. And that's a timing problem, which means that the person, there may be a lawyer at that bail review, but that it's not a lawyer who has, the counsel hasn't yet been appointed for this person yet. And so that's a practical problem. However, the findings that judges make are very, look the same as the findings that hearing officers make. They have a slightly different form that they use, but they are looking at the same standard. Is there clear and convincing evidence? they, describe their reasons for their ruling, either in person or on the form. And so we do see, it's a similar standard, it's the same standard, similar form. I think the other challenge that we've described in some of our reports is what happens when those bail review hearings don't happen. And the person has a right to have them happen, but there have been cases where someone is under medical supervision or just isn't brought up on time to that hearing, and it doesn't happen the way it should. And they don't have counsel that has been appointed for them who could advocate for them if they're not there. And so there are real practical challenges that we do think that there are some ways that that system could, those inefficiencies and problems could be prevented, but right now they do occur.
I can also comment on that of what I've seen. So when folks are still in custody and there is a bail review hearing, that's the first thing I'd look at every morning. We look at our docket. I'm looking at who's in custody, why are they still in custody? So I'm circling, I'm highlighting on each of my docket pages. I know who I need to talk to that day about a bail review hearing. And if the folks are in custody, they immediately get a lawyer when they come through court 8. But there are issues, we have like medical quarantine or something that's going on. So it is harder for the lawyer to advocate on the defendant's behalf because they don't know what's going on. But it's consistent in court 8 where they're coming and talking to me and maybe asking for a reduction or a change in the bond condition. So I see it, defense attorneys consistently doing that every day, every single day, because I have it highlighted and they're coming to me. But of course, there's also issues where they have no control, or say if there's an ICE hold or something like that, because no matter what I do on my end, the person's still going to be in custody.
Thank you so much. Okay, we have 2 questions from Mo Cortez, policy organizer with Grassroots Leadership. The first question is, he wants to know for anybody on the panel if they support the implementation of the JMI recs for clemency for nonviolent offenders, if you're familiar with those recommendations.
I'm not familiar with them.
Okay, that's what I thought. It may be more of like a Harris County thing, but let's go to the next question. And then Mo is curious if any of the monitors have actually taken a tour of the Harris County Jail.
Yes.
Yes,
We all have.
they both have. Okay, thank you. Okay, next question is from Melissa with Community Impact. With the latest report released this month, what top 3 to 5 data sets would you suggest would be best to highlight to readers in order to communicate the various progress highlights addressed today?
I kind of think the main above the line findings, like we highlight just in the upfront executive summary of our report, so that to make them easy to find and so you don't have to get lost in all the tables and other findings. So the short executive summary is definitely the place to start with our reports. There are good kind of day-to-day updated data summaries on a data dashboard that Harris County has prepared. And that they've really developed, consent decree calls for public-facing data, so that any given day you don't have to wait for a report from us. You can see data from the county at any time, and that includes data from the courts, reflecting the work of Judge Ramirez and her colleagues. It reflects, who's coming in based on having a misdemeanor arrest, and a whole series of different outcomes have all been built into this dashboard, and that's updated. I don't know if it's real time or just every day, but it's definitely updated at least daily. And so that's a more sophisticated current source that you can check. But for just simple findings, we try to provide the most basic findings in the executive summary up front in our reports.
Awesome. Okay. Another question from Joy Davis. So under the current political climate of this federal administration, do you expect any changes to be made to the consent decree?
I don't know about that. The consent decree is a settlement and was finalized years ago. It's been 5 years now. We did see already last year an increase in ICE holds in misdemeanor cases. And certainly, the current administration, federal administration, has said that tough immigration enforcement is a priority. And so if that's right, then we might see a further increase in ICE holds. And, as Judge Ramirez said, that sort of takes the question of bond in some ways out of the judge's hand. Like they must be held pending potential ICE custody. And so that may mean that, there are more cases that pose a financial and space burden on the JPC. And they may pose some real challenges if the numbers get much greater than they are now for the courts and for processing. But we don't have, I think it's a little too soon to tell. And we actually did see a real increase in ICE holds last year, during the last year of the last presidential administration. So those patterns have changed over time, even within administrations. So I guess time will tell.
So if the federal administration were to eliminate consent decrees, how would that affect the O'Donnell consent decree, and would that affect the policy, seeing as how it's already in place?
I think there may be some understandable confusion there. So the Department of Justice, the U.S. Department of Justice, enters its own consent decrees in civil rights cases, and different administrations have had different policies about what civil rights cases are appropriate for settlement through consent decrees, or what civil rights cases they want to bring it in the Civil Rights Division at the Department of Justice. But the O'Donnell case wasn't brought by the federal Department of Justice. It was brought by private civil rights lawyers. And so it is in a federal court, but it wasn't a consent decree that was litigated by the federal government.
Awesome. I think that is it. There are no additional questions online. Last call for in-person.
One more.
Well, if there's nothing else, that concludes our meeting. Oh, yep. There we go.
Hello again, Selena Bray with Pure Justice. I was wondering if y'all could speak to the refreshed training for judges and magistrates, and relatedly, with the next phase of pretrial videos, will the judges be looped in to those or made aware of their proliferation?
Yeah, so I can kind of answer that. So yes, the refresher training, so a part of the consent decree is that we provide annual trainings to attorneys, judges, and the magistrates. And so because a number of the judges and attorneys have already taken this, it's more of a refresher course. We also are designing an onboarding course, as the Public Defender's Office and the MAC often like to use that training to help introduce the O'Donnell consent decree to new attorneys. And so our Office of County Administration is responsible of that. And so we're kind of using some of the training material, but it's really, again, just to kind of refresh them. What we do to update the trainings is provide updated information. So as Attorney Hopkins had mentioned, the non-appearance plan will provide updates into there, but that's what that refresher training looks like. And if you could remind me of the second question that you asked, sorry.
Yeah, for I believe it was the second phase, that'll be the increased re-entering services, like the videos for pretrial people. Will the judges be aware?
Yes. So what we're doing, we Attorney Hopkins kind of mentioned this, but we consult with pretrial and the Office of Court Management. And so actually the judges are really interested in kind of being a part of those educational videos, but we want to ensure that we have that information correct. And so the non-appearance plan is actually online on our website, and you can see all of the recommendations. So there's 5 different videos from, how to use the non-appearance website, what to expect at your first appearance arraignment, what to expect between the different bonds. So it's really kind of breaking it down. If you kind of think about a person who's first time being arrested, they have no idea how to navigate this system. And so there's 5 specific videos. And again, that non-appearance plan was based off of research conducted to see why individuals don't show up. But yes, we are planning to work with the Court Management Office and the judges, as well as the plaintiffs, because that's a requirement of the consent decree, to ensure that everything is captured in those videos, and that will be released to the public.
In the videos, there are basically 2 prongs. One is to explain sort of your legal rights. And then the second, we also want to talk about practical considerations. And it's everything from where to park, how to get through security, where to show up, where to get additional information, even like what does a courtroom look like? Who do you check in with? That kind of stuff as well.
Thank you.
I have a question for you.
Yeah.
When are you going to go to law school? Because you are our future, ma'am, and I cannot wait to see the things that you do.
Oh, thank you for asking. While I don't have a definite timeline, I can say that your question will make my mother very happy. So pass on. And I do have another question, if I may.
Yes.
For the request for additional 4 criminal courts, that's really substantive. Thinking a couple of things. One, as you said, the recommended number for a city like Houston would be 27, and 4 would get us up to 20. If we're currently at 16. I know it will be in the limbo at the legislature, but can you tell us more about what that process would mean, or like, do we need to do redistricting concerns? And 2, as we know, the city of Houston population continues to grow. So are we going to be in a position of kind of stopgap creating courts until we get the backlog back? Or just wondering if y'all can say something.
That's a great question. I mean, so ideally, we would ask for 10,
Yeah.
but we're trying to be, understanding that this is a huge community and everyone has needs. I'm so grateful. I've worked in the government. My parents were government workers, so everywhere is in need, and we acknowledge that. But it's definitely something we're talking about all the time. Okay, so if we get these 4 courts, where are they going to go?
Right.
Is there space here downtown in a central area for folks to all join at, right? So we're talking about the engineering cost of that, the cost of the personnel in each court. It's not just the judges there, right? We have the district clerks, the probation officers, the bailiffs, our coordinators, everything. We're a team there. So it is a process. We are asking the commissioners. We have commissioners court coming up soon. It's about getting their support. But if we get their support, which I'm so hopeful, because they do understand the need for our community, then that's when we go to the legislator. So it's step by step, but we really are working at each step to make sure that we're getting the funding, that we're getting the personnel and the space so that folks can have their day in court. Look, the criminal justice system, it impacts everyone. It's not just those charged. It's their family members. It's their coworkers. It's their kids. It's everything. So the sooner we can get the folks who have been impacted by the criminal justice system in and out and moving on and doing better, the better we are. So thank you for so if you want to support us, go ahead and call your commissioner, call your your rep, let them know that we need it.
Yeah, thank you.
And before you go, there's another comment in the audience that agrees with Judge. Okay, thank you. Okay, and it looks like one last question from Mo. So if Harris County were to open a $7 billion new jail, would this negate the work that is being done? I'm not sure if
I guess I would say like very few people in misdemeanor cases, absent the ICE holds, are in the jail. And so that's been one of the accomplishments of the consent decree, that it had been the case that about a third of the jail consisted of misdemeanors, mostly spending, 1 to 4 days or something like that in the jail. But there's a large number of people cycling in and out of the jail in misdemeanor cases. That's not true anymore. And so whatever space issues the jail has with the population, the vast bulk of that now is not misdemeanor cases. And so not something that we're studying.
Okay. Thank you. I think that's it this time. Okay. So that does conclude our meeting. Thank you so much to the panel, and thank you so much for those attending in person online. We'll see you in the fall.
Thank you.